Okay, welcome back to this evening session. And like I said, the marks for assessment one have gone up. And although I've not been able to send you back individual feedback, and certainly because of my issues with my back, I wasn't actually able to do full feedback on each of the scripts as I usually do, because I was under pressure then to rather to get the work, um, get the marks out to you timelessly, because as you are also aware, the time for our, sorry, I've just got so many things plugged in here, um, for our final assessment is drawing close. So I just wanted to settle your mind on that aspect. So you've got your assessments with you, the original versions that you would have emailed me. I've not, unfortunately, like I said, been able to send you back individual feedback, but we can discuss what was expected from you guys. And I have to say that this time round, compared to, I mean, those that did specific offenses with me last semester, I think by and large, I'm happy to say that you've dealt with this topic and this piece of writing in a much more mature and informed way than you did the previous one. And the marks certainly reflect that. And that's true for every year, pretty much, when students learn the lesson a hard way, if you want to call it that, from, just taking things for face value and not honing in on what the actual issues are. So by and large, I'm very pleased with the quality of work that has come out from both the full-time and the part-time class. And I'm also happy with the way in which you applied your mind generally. Of course, there were some hits and misses, uh, but largely, mostly good. So having a look at this question, I just wanted to say that what sorts of things was I looking for in this? Well, first of all, this was more like a discursive essay. So it's a discussion, um, and a debate, if you will, regarding alternative systems. If you want to call it alternative systems, but those of you who wrote particularly clearly would have sussed out that we're not looking at it as an alternative system, but rather a parallel system, which can work, does work, but for particular types of matters. So that's where and this sort of leads towards the conclusion part. But if we're starting out, we're talking about historically. Historically, what sort of system of justice, as far as criminal justice is concerned, exists in South African law and in our criminal courts? And here we're talking the whole debate between crime control versus due process, but essentially that it is a court system, that it is adversarial, and that there are also other forms that have tended to exist in a parallel fashion historically. And you also have picked up on things like tribal courts and tribal headmen's courts, if that's the way you went down. And then move on to giving some sort of definition or discussion regarding what these parallel, not going to call them alternative, parallel systems are. And you'd be pointing out that they're not unique. These parallel systems aren't unique to South African law or the African diaspora. That when we look at places like Canada, the Americas, these parallel systems do exist. They may call it something else, but they do speak a lot about restorative justice and mediation. And then you'd offer a definition or definitions from the various authors and academics who have discussed that. And beyond that, you'd be talking about efficacy. In other words, when does it work? Do these parallel systems work? When is it appropriate to use them? And that's why we're saying parallel systems as opposed to rival systems, or a system that can wipe another system out. We say parallel because and when we talk about efficacy, can they work? Yes, they can work. Do they work? Yes, they do work. But for things like minor offenses, for things relating to juvenile offenders. And from a local perspective and a South African perspective, we see it working very well, or have worked as a forefront in our example of the TRC. So you'd be referring to those sorts of examples and even South African case law, which discuss the value that a system of restorative justice or mediation can offer in a criminal justice system. Some of those benefits would be cost saving, cost saving, and the fact that the court rolls are so full. But beyond that, going more to rehabilitation as opposed to retribution. Okay, and some of you have certainly argued and discussed, and that's where you scored well, about theories of justice and principles of justice, and are there less restrictive, less damaging ways, less destructive and disruptive ways of achieving the same purpose? So the traditional system versus this restorative justice system, can the same objectives be achieved through less drastic means? But again, important to point out that it won't replace a traditional system. And this is what the authors say, particularly as it relates to the nature of the offense. And so more serious offenses, in terms of boni mores, in terms of what type of protection society requires, and also taking into account not only the crime, but also the criminal. So what is this offender's particular needs, and are they a suitable candidate for this type of rehabilitation and restoration? Does that make sense?
Yes, ma'am.
All right. So that's essentially, and it wasn't terribly difficult, a terribly difficult one. You just really had to do the readings and wrap your mind around what is expected of me? What am I meant to be discussing? What philosophical point? So this was a different type of essay, like I said, discursive and debating, and very philosophical in that sense. All right, so I don't know if you've had an opportunity to look through the tutorial question. I mean, sorry, look through the slides and the audio. I don't know if you've got that. I've managed to do that. But this week we're meant to be talking about bail. And it comes, you know, happily or unhappily, it comes at a time when in South African law, several bail topics are making media headlines. And do you want to tell me what some of those are?
Dr. Bushiri.
Yes, Bushiri is the one. And the other one?
Magashule.
Magashule, yes. And we're seeing, and it's fantastic as a learning tool. You can see I get excited about bizarre things, but it's fantastic as a learning tool. So what I've uploaded for you is the bail application for Ace Magashule. And it's a wonderful way to see and experience, in a sense, without personally being in court, what the arguments and how a bail application transpires in court. And going through the slides and going through the audio, you'll see the types of arguments in relation to Section 60 of the Criminal Procedure Act, in relation to the Aikson case, in relation to the Dlamini case, how the courts have to consider whether or not this accused person ought to be granted bail, right? And having made that decision, okay, so before we get into that, let's ask, what is the purpose of bail? What is the job of bail? What does it do? So when you hear that a murderer, an accused, someone who's been accused of murder, has been let out on 5,000 Rand bail, what do you feel?
Oh, that's too little.
Beg your pardon?
It's too little.
It's too little. And what makes you think it's too little, Tobeka?
Um, comparing the gravity of the crime with the amount. I mean, if someone is capable of murdering someone and then going out there to the public, who knows what else he might do.
Right. But at this stage, at the bail application, has he or she been convicted?
Right? No.
Right. So that's important. But so many non legal people have that reaction. Where's the justice? How can he be? He's a murderer. She's a murderer, a rapist. How can they be let out? Where's the justice? Let's start by asking, well, what purpose does bail serve? And we left off at the last session, ouch, at the last session, where we said that there were various ways. We haven't even gotten to the trial yet. We're still talking about how do we make sure that an accused person comes to court for the trial. So the bail isn't the trial. The bail is an inquiry to determine what the likelihood is that this accused person will come to court for his day in trial, a day in court for his trial, without us having to keep him incarcerated in prison. Because the truth is that the the process can take a long time. And if we think about the presumption of innocence, you are innocent until proven guilty, innocent until proven guilty. How would you feel about spending months and months imprisoned only later to be found and held not guilty? Now, various things can happen. You could have lost your job, your spouse could have left you, you'd have lost your home. All right. And that certainly would feel like an injustice. Second, another point is that our jails are also very, very full. And as far as possible, it's not desirable to have it filled with awaiting trial prisoners. But yes, there are things to consider, like the nature of the offense. And we will talk about, well, how do you determine what is a good amount? What is an amount that's fair enough? You've got to also think about, well, what is the point of this sum of money that's paid over? The sum of money is meant to be that security. Security to whom? Security to the state that the accused person does intend to come to court, and it's certainly an amount that he or she wouldn't isn't small enough or trifling enough for him or her to say, ah, well, I don't need 250,000, I don't need 5,000, I don't need 1,000. Okay. And for that, the amount it takes into consideration things like uh, assets, bank balances, salaries, expenses, expenditures, etc. Now, over and above that, and if this all will come clear to you when you go through the audio and the slides, various other factors, things like dependence. Is the accused person who's making this bail application the sole breadwinner, caregiver, whatever the case may be? What will, if this person's got small children, what will happen to those small children if this person is incarcerated for all these months? Okay, so there are very many factors that need to be considered. Now, as we saw in this Bushiri case, what was the bail amount? 250,000. And they handed over passports, but they still managed to abscond. So there is something wrong, but perhaps not with the justice system necessarily, with other factors. And so the question of constitutionality of bail comes in. When we look at Section 35(1)(f) of the Constitution, holds pretty much that every accused person has the right to apply for bail. And what that means is that every person can apply for bail. It doesn't mean that every person will be granted bail. And the factors and what is concerned when we determine whether or not bail should be granted or should be denied is what we call the interests of justice. And that's extrapolated or elaborated upon in terms of in the Criminal Procedure Act, Section 60, and the various subsections, which we go through over the slides. and more particularly these two cases, Dlamini and Akerson. And if you listen to and watch that video of Ace Magashule's bail application, you will see that the advocates on both sides do discuss these cases, as does the magistrate when he's handing down his decision. So the interests of justice don't only consider whether or not the accused person will come to court, but it also considers justice, meaning the rights of the accused person and any other people affected thereby. And that could also be, so like we said, dependents, spouses, but it could children. It could also be witnesses and the accused person himself. So sometimes bail is denied not only because the accused person may be a threat to witnesses or to other people because he or she's said, oh, I'm going to find you and I'm going to get you, those sorts of things, whatever the case may be in a practical sense. But maybe members of the public have made threats to the accused person, and it is not simply not safe for an accused person to be released on bail. There's a lot of factors. Okay, so here are some of the factors. And like I said, section 60, subsection 4A to E, which is elaborated upon in the Dlamini, in the Akerson case on how should a court consider what these are. Whether there's a likelihood that the accused will endanger the safety of the public or any particular person, will attempt to evade his trial. And those are the two sort of common sense ones. Influence or intimidate witness, undermine or jeopardize objects, disturb public order. But again, there are very many other factors. And when we look at, let's go down here. Sorry. Yeah, when we look at how the Akerson decision looked at this, looked at these factors, it elaborated. So all of this, well, does he have emotional ties? Does he have family here, dependents here, assets here? In other words, how difficult is it? What is holding him to South Africa, or how versus how easy it is for him to just say, I'm just going. Nothing's keeping here. I've got nothing worth staying for, and so I will just leave, and I've got nothing to lose. Okay, and that's where we're talking about things like travel documents, passports, etc. Further thing, and this is also determining what bail conditions would be, and we'll talk about bail conditions. For example, handing over your passport, no drinking, reporting to a police station regularly for like an attendance register, etc. But another factor that comes in is, well, the health of the accused, and what will staying in custody mean for the accused person's health, and will it be more detrimental in the sense that it works out to be a punishment and more severe, right? Because that is also what we want to avoid ultimately. Like I said, various sort of factors and conditions can be raised when if the court says, okay, we've considered your bail application, we've heard the reasons from your attorney, from your advocate as to why you are not a flight risk, and we've heard argument from the other side. We've also heard about your financial status, and now we need to work out how much is a fair amount for you. And often the defendants, the accused side, will often say, look, my client can afford 5,000 rand bail, or 1,000 rand bail, or 250,000 rand bail, right? And the state will maybe come back and say, no, look, let's look a little more closely at his banking details. He can actually afford more, right? And he ought to, given the nature of the offense, all of his means possibly to leave, to disappear, etc. Okay, so in making bail conditions, yes, we are granting you a bail, we are granting you bail in a particular amount, but we are putting restrictions on your movement. So we are restricting your freedom of movement. Where can you go in the province, outside of the province, handing over of passports, like I said, regular reporting, not to contact any witnesses, not to interfere with the case, not to go to certain places like pubs, clubs, casinos, etc. Right, and the procedure, of course, is one where the The record needs to go to the clerk of the court. The clerk of the court then issues a, well, you've got to then pay over that bail amount. You get a receipt. The receipt, then take a copy of the receipt to the holding cells. Once the receipt is shown and handed, a copy is handed over, then the accused is released. What happens to that bail money? What happens to that bail money once it's paid over? Well, two things. If the accused absconds, as we've seen in this Bushiri case, where the accused absconds, then that money is forfeited to the state, right? If the accused, however, doesn't abscond and the trial continues and comes to a conclusion, and when I say conclusion, I mean either a guilty verdict or a not guilty verdict, regardless, that money is returned. So even if you are found guilty, if your client is found guilty, provided that he fulfilled his bail requirements and the bail conditions, and he came to court regularly, did not abscond, didn't violate any of the conditions, that money is handed back. Why? Because the bail money is not penal. The bail money's got little to do with the outcome of the verdict, in other words, the guilty or not guilty verdict, right? It's got to do with securing the attendance at court. Okay? All right. And then the tutorial question, I think we have some time to look at, but I think it will be more meaningful for you once you've watched the Ace Magashule bail application to see how the arguments would be made. But let's just have a look at it, right? So I'm just going to stop that now and open something else. Okay, so this is the tutorial or the in-class exercise that goes up. So on the 9th of August, Harry and his wife are disturbed by 3 intruders while at home on his small holding 10 kilometers outside Pietermaritzburg. All intruders are armed and proceed to tie up both Harry and his wife, but not before Harry sets out an emergency alarm linked to his neighbor. Intruders ransack the house and in the process take Harry's wallet, his wife's purse, and a TV set. Harry is then viciously assaulted and forced to open his safe, which contains 2 firearms and 15,000 rand in cash, being the monthly wages for his employees who work on the small holding. Thereafter, Harry is assaulted again, and so is his wife. All 3 of the intruders threaten to rape her, and in the process of commencing this act when they are disturbed by the neighbors responding to Harry's alarm. They flee into the darkness, but one of them is apprehended about 200 meters from the homestead. 10 days later, Sam is arrested in connection with the above attack. He is arrested at his home in Albert Falls, which is about 5 kilometers from Harry's small holding. His circumstances are as follows. He is 19 years old and is currently staying with his elderly maternal grandparents in Albert Falls. He is attending the local school and is currently in grade 11. His form teacher has indicated that his academic progress is satisfactory, but that he is absent from school quite frequently. She is of the opinion that his grandparents are unable to exercise control over him, although they do provide him with his basic needs. Both his grandparents are pensioners struggling to survive economically. His grandmother is suffering from cancer and has been given 6 months to live by the doctors. His mother has remarried and is at present living in Durban. Occasionally, she sends support money to the grandparents, but Sam has not had much contact with her. His father's been deceased for more than 10 years. He participated in an identity parade where 2 co-accused were pointed out by Harry. Sam, however, was not identified. He participated in an identity parade. Oh, sorry, I said that. During a search and seizure operation at the time of his arrest, a shoebox containing 5,000 rand in cash was found under his bed. Sam alleges that this money was received by him for repairing radios. Sam has 1 previous conviction for theft of a bicycle. This occurred in 2016, and he was sentenced to 6 months imprisonment, suspended for 3 years. Okay, so on that last point, I didn't mention, but it is in the slides that part and parcel of what is argued and what is presented in court is the accused's previous convictions. In other words, does he have any previous convictions? And also, is he currently out on bail for another matter? So that's also one of the factors that need to be considered, and it will become more clear to you when you're looking properly addressing the tutorial. Now, a question like this in an exam or a portfolio assessment situation would usually be broken up into three parts. So I'd say to you, as the attorney representing the accused, make an argument in favor of the granting of bail. Secondly, as the state, make an argument opposing bail. And thirdly, as the magistrate, make a decision on whether or not bail should be granted. So that's the factual scenario. And these are the personal circumstances. So these are the factors that will be brought forward in court to help a magistrate determine whether or not, amongst other things, Sam is a flight risk. Also, how much money could he possibly pay for towards his bail? It's also an indication of what type of conditions a magistrate might want to impose. Now, it's not done arbitrarily. It is done in terms of what is explained in terms of section 60, subsection 4, and the various subsections A through to E there, and looking more closely at Akerson, Dlamini, and Schietkart for an indication of how that would play out. Now, both sides would be relying on those same sections to prove or show that this means that he's not a flight risk versus this means that he is a flight risk. Okay, so if you want to talk to me generally, what do you think are the points that could possibly be raised, just looking at his personal circumstances and what we've discussed generally about what the purpose of bail is?
I think for me, the first thing would obviously be his age. He's young,
Mhm.
and he obviously doesn't have like a means of earning a living.
Okay.
Since he's still in grade 11, so I wouldn't necessarily say that there's a risk of him leaving the country, especially since he lives with his grandparents who are ill. It says here one or his grandmother um, has been given 6 months to live, and I think it would be unfair to hold that person in a cell with a person who is about to die.
Yeah, well,
Um,
okay, if I'm going to counter you, right? So let me counter as you speak, because this is what you're going to have to write in the other part. That it's not only about whether he's going to leave the country. He certainly doesn't have the means to leave the country. And he probably also doesn't own a passport. But given that he has, you'd have to argue that his emotional ties here are strong enough that his responsibilities here are weigh that heavily that it is unlikely that he would even leave the province or leave the district and become unfindable. Because even though the teacher claims, and to say that he should not be granted bail, right? The teacher says that he comes to school sporadically and his grandparents don't have control of him. But on that same point, he goes home every night, right? And he is attending school, albeit sporadically. So there is a way. He does have some ties to this place. You need also then, so if we're moving on, right? We also need to talk about the nature, the offense of which he's being charged, and in connection to that, the strength of the evidence. In other words, the likelihood of there being a guilty verdict made against him. Talk to
okay.
me, make sense to me of this identity parade, because that's important. And anyone, please join in where you feel necessary.
No, that threw me off. the fact that he was not identified.
Yeah, so that would say on an evidentiary basis, remember I said that these identity parades are important because it will come out in court that not once was our client or my client fingered or pointed out in the identity parade, right? So that means that the actual evidence against him isn't, from the eyewitnesses, isn't very strong. But they're saying that there were assailants, three assailants, and an amount of 15,000 Rand was stolen. Split three ways is how much?
5,000.
5,000. So where did this 5,000 Rand come from? Okay, so again, it's thin unless they can, and it'll have to come in court in the actual trial, say that, look, these serial numbers match or are consequential to the other 10,000 Rand that we found. But it's very circumstantial, very circumstantial. And unless in trial, one of the others, and this is way ahead of the game. So, because, and right now we're not, although we're not talking about guilty or not guilty, excuse me, we are dealing with whether or not he will want to stand against and defend himself and let the trial go ahead, or is he going to abscond and run away? How would you go ahead?
One of my questions is that Harry pointed out to, because now I'm thinking, was it not the police that caught Sam?
The police came and got Sam.
The police came and got Sam.
They put him in the lineup with two other people.
Which were positively identified by Harry.
Yes, but Sam wasn't.
Because now I'm thinking, like, okay, yes, the crime, it's like there was bodily harm and all of that, but he could have just have been an accomplice. That's also possible.
Well, we don't know. We don't know. But what is important here is that he wasn't identified. He was in a lineup, and the witness wasn't able to point him out.
Sorry, ma'am.
Go ahead.
I thought maybe by judging the number of days, it's been 10 days since the incident, and he's still keeping. Maybe I would assume that he was part of those intruders. He still kept 5,000 as it is. If it was somebody else, maybe the person would have used the 5,000 already, judging by the number of days. I don't know if I'm making sense.
No, you are making sense.
Maybe it's possible that maybe he kept it for a different reason, maybe to assist on assisting the grandmother.
Or maybe genuinely it is from his earnings, as far as whether or not he, as he claims, from his work repairing TVs.
Yeah.
Now,
one
of the things that you also need to know is that in a bail application, it's procedurally different. So remember, we spoke about the difference between crime control and due process. And in a trial, the judge sits as an independent umpire and doesn't descend into the arena. But in a bail application, the magistrate does take a more active role. So even if Harry wasn't represented, if Harry didn't have an attorney representing him, the magistrate would and should, it's required to say, listen here, son, or my boy, or whatever, or Mr. Sam, do you want to apply for bail? And then it will take on from there, right? So that's the first thing. Beyond that, the magistrate a good magistrate would say, hold on. He's saying that he got this money from repairing radios. Is there anyone, can we get a statement from anyone to say that, yes, this boy has been repairing radios, or did repair my radio, did repair my TV. And oh, of course, it might not have cost 5,000 Rand in one go, but he's been doing this, and for other people in the town, other people in the community, he's been doing this for a number of years. And, you know, just to show that, look, he is trying to earn something, and there's a logical explanation as to where this 5,000 Rand could have come from.
Yeah, but sorry, I just want to go back to Mzo's thing earlier. Remember that Sam is the one that the parents he's the breadwinner at home. So he would have.
Do we know that? Do we know that? We don't know that he's the breadwinner. We are told that they're unable to exercise control over him, although they provide him with his basic needs.
Okay, no, I must have been thinking of another case then.
No, but you know, I know where your mind is running. She's got cancer. So maybe the logical explanation is the reason he's not at school is because although she gets her pension and they're living as a family of their pensions, he is providing her with emotional, physical, and other support. And he's still succeeding at school despite his absences. So if it was me giving the judgment, and the next thing we need to talk about is this previous conviction from 2016. He was sentenced to 6 months imprisonment, suspended for 3 years. Now, by my calculation, those 3 years have come and gone. And so he's not at risk. This no longer applies pretty much, right? Although he does have a conviction, right? Yes?
Yes.
So it counts in his favor that this was brought to their attention. It cannot count against him in that, within your suspension period, we've now arrested you for something else. Now, if I was the magistrate in this matter, I would probably grant bail. Right? And the conditions would be that he must start attending school more regularly. Alternatively, report to the investigating officer on a weekly basis. Yeah, or a church leader or something like that, that he undertakes not to interfere with witnesses, etc. And then I've got to still think about an amount. So in these circumstances, what would be a fair amount?
5,000.
5,000 is a bit harsh. 5,000.
No, 2,000. 2,000 is, I think it's justifiable.
I
Reasonable.
It's fair.
2,000 is harsh.
It's not harsh. I mean, these people,
Where's he going to get 2,000 Rand from? Where is this boy going to get 2,000 Rand from? Think about it.
No, he has 5,000 Rand. He can take 2,000 from that.
It's in custody. Ouch.
Okay. 500. I think 500 will be enough.
Right. Now we're talking a better number. But what if I said to you, this is a situation where I would release him on bail on his own recognizance? Or even an amount less than 500.
Again, you are so lenient.
But what I'm saying to you is 500 would be more reasonable. I still think 500 in these circumstances is too much, particularly because the evidence weighing against him is so thin.
Okay, that makes sense.
I know we understand that the money will be returned. Okay, but for now, in his personal financial family situation, is he going to be able to scrounge up 500 Rand? Because even if I set bail at 500 Rand, it means that if he can't pay it, he's going to stay in jail.
Yeah,
and so the bail amount is just a philosophical thing. Another option is to say 500 Rand, but someone has to stand as security for you.
Okay.
Someone has to give it.
One other thing that I thought maybe I'll look at is maybe since you are making the judgment on the bail, would you consider the condition of the grandparent, the one that is sick?
Mm, how so? As in her health
Would
status?
you consider the condition?
Yes, I mean,
Yes, her health status. Would you
obviously, like
put
I
that in
said,
consideration?
yes, but like I said, the facts that we've been given are scant, right? In verbal argument, and this is what you would be arguing in your written format, you will have to embellish and tell me she is in poor health. Sam is the one who takes her to the hospital. He, scrounges up whatever money he can from radio repairs to get her into a kumbi, to get her to Edendale Grays, wherever, whichever hospital, and get her back. So in your writing of your argument, you get to embellish. Now remember, in real life, you can only embellish as much as is the truth. But you're given some
Yeah.
poetic license in this question. So don't just rewrite, he is 19 years old, he goes to school, as I've put it out. Make an argument. And because you've got to make argument on the other side, refute that argument.
It makes sense.
Right.
Mm.
Okay. But watch the Ace Magashule video, and you'll see how those arguments are made. And although that is for a big fraud matter, the arguments essentially are the same. You're still looking at Section 60 of the Criminal Procedure Act. You're still looking at Akerson. You're still looking at Dlamini. Yeah. Now, obviously, in the facts that we were given, it would be ridiculous or nonsensical to say surrender your passport if he doesn't have one. All right. Okay, so if everyone's happy with that, I will see you all next week then. Thanks, everyone. Take care.
Thank you. Thank you.